Thank you. I want to welcome you to the second panel today on this most interesting evolving area. I hope you can hear me. And we want to thank Bankole for inviting me to chair this panel. And I trust that it will be a very interesting panel in terms of discussions and take-home points. One of the characteristics of law is certainty. And it is clear that the rules-based order is an evolving concept. Now, if public international law is working, some say it is not, but if it is working, the question is why change a winning team? Does the rules-based order seek to supplement or supplant public international law? The session this morning, a number of prejudices have been expressed. And this afternoon's panel is going to take the issues further. And it's my pleasure to introduce, no particular order, Dr. Ejims, who is a senior lecturer at the University of Bedfordshire, who will be discussing on issues to do with challenges and examples in the area of international investment laws, looking at arbitration awards and enforcement and things like that. We have Dr. Iino, Associate
Iino, thank you.
Iino, sorry.
No problem. Sure. It's Iino. Thank you.
Yeah, Associate Professor, College of Commerce, Department of Commerce, Nihon University. And she'll be speaking on issues of trade subsidies, trade law and subsidies, which is very, very, very topical. And we see how farmers are complaining in Europe. And we also have Professor Federico Lenzerini from the University of Siena, who will be addressing us on indigenous people's rights and drawing from his own experiences. And finally, Professor Alexandra Xanthaki, who is a UN Special Rapporteur on Cultural Rights. And from that perspective, she will be drawing from her role as Special Rapporteur. They have 10 minutes, 8 to 10 minutes each. I'll signal them if I think they've used up their time or they're almost finished in time, but I trust they will keep to their time. So let me call on Dr. Ejims, okay, to start.
Thank you, Professor Bankole. Thank you for your kind introduction. And I would like to thank the organizers of this event for inviting me. It's a pleasure for me to be on this panel and to be able to present my ongoing work on climate change in African foreign investment law, which will be an AU perspective on the rules-based international order, which is grounded in international law. Again, a very, very thought-provoking discussion in the first panel that talked about what is this rule? And I would more likely lean towards a rule-based order that is based on norms and agreements states have decided to abide by. And in this case, rules that could create new laws in this regard. In my research, I had a closer look at the concept of climate change in AU law and international law. And what I did finally, even though not exhaustively, I looked at some examples of where the contribution of the African Union are worthwhile considering. I'll give a little bit of context, as Professor Bankole has mentioned, about investment treaty law. We all know the issue of climate change in Africa, more especially like flooding and drought. And I think the priority for Africa now is to receive and support investments to build resilience and adapt to climate impacts. However, we will have to look at the more harrowing issue with the international law regime that governs foreign investment, which hinders rather than crystallizes this transition to climate-friendly investment opportunities. Investment law, which are made up of investment agreements and also the reach investor-state dispute settlement, particularly work against climate goals. I would like to draw our attention to the fact that this particular system could choke climate change actions in emerging economies. A recent report by the Colombian Institute of Sustainable Investment has clearly stated that African countries are exposed to rising investment treaty claims. And we all know here that most of us who are specializing in this area, that billions of dollars have been awarded against states in favor of foreign investors to compensate them for investments that have been affected by new measures to promote climate action. More specifically, I think such expensive way of settling disputes, and more especially the compensation, could expose states to huge financial commitments, which could cripple them financially. Zimbabwe, again, Mozambique was specially singled out in that report. Mozambique has investment agreements and contracts with foreign investors and also with other foreign states. I think with the market, which is growing now in Mozambique, which is the fossil fuel market, LNG markets, that could expose them again. And that report says it could expose Mozambique to about $29 billion claim against them. I think we all know that most of these countries, the 10 years budget expenditure for things like poverty and health would equal that type of compensation, which in its effect will cripple the government, and also the implication will be to have a chilling effect on the state's ability to pursue climate goals. Now, despite the challenges posed by these investment treaties, the AU has shown itself as a leader in international trade and investment, of promoting a kind of value-based policy in taking into account climate goals in its constitutional act as well. So I'm giving a kind of basis for the contribution of the AU and how the AU has come into reconceptualizing investment law. Now, the strategy aims at the improvement of the AU's ability to make its own choices and to shape the world around it through leadership and engagement, reflecting the AU's strategic interests and values. And these values also include climate change. Now, it sounds like a kind of political challenge. How can we in Africa get it right that climate change is integrated into economic agreements? Now, for the AU, it's not political, it's a legal challenge. Why is it legal? We all know that the entry into force of the AU Act, which is the constitutional act, the AU has a legal obligation to take climate change into account in its commercial common policy. So here, it's based on all these elements, affirming leadership and having obligations to integrate climate change and having the competencies to act in foreign investment, led me to formulate the role of assumptions. We all know that as legal scholars dealing with climate change and investment law, I would like to point out that they are based on assumptions. And key assumptions is that investment law can enhance climate action. Now, underlining this assumption is the famous dual link, which most of the investment law experts know. On the one hand, we assume the correlation between foreign investment and climate change, and we accept that investment agreements can enhance sustainable investment flow. But it's also important to note from both, we do not have clear-cut economic evidence. So from economics to tell us whether this is true or not, but that's why I needed to highlight this assumption. Now, the other assumption departs from the fact that we are in an ongoing reform. I would like to also stress that there's an assumption on the need for the reform of investment law regime, and this reform should be done in the light of climate change mitigation and adaptation. Now, how do we examine AU as a global order in this regard? What I did was to apply a method, which is a double benchmark method. This is to say we have to examine the AU based on two normative frameworks: international law that governs climate change, And the second is the self-imposed obligations by the African Union in its constitutional principles. Now, more concretely, we have on the one hand, climate mitigation and adaptation in international law, which is the Paris Agreement. What do we think of the Paris Agreement? We think of the objective is to reduce the global temperature increase to below 2 degrees. And secondly, on the other hand, if we look at investment law, we do have recent state practice where states try to find ways in which they integrate climate mitigation and adaptation explicitly or in some indirect way in international investment agreements. There's enormous work done by the OECD and UNCTAD in this regard, but I won't go into detail in that regard. Now, in relation to the AU, we have already seen that the AU's objective, which is to promote climate change, is quite important because in the AU law, the principle of integration is key. So our emphasis of the AU framework is integrating economic integration and also integrating principles of climate change into AU law. Now, I would like to move on to a brief information on concretization. So if we start with the concept of climate change, we also have to look at how climate change can be integrated into other policy areas. But today we'll be looking at investment law policy. Now, from this policy, we need concretization. What do I mean by concretization? As lawyers, we need to look into how treaty text is actually being drafted. So what is the legal instrument we're looking at? The AU investment law. So let me quickly move to the part of the research analyzing AU law agreements. Now, I have looked at the AU law agreement. I don't have slides, but what the AU law is doing now in the new investment protocol that was adopted in February 2023 by the African Union states, it's important to note that the AU agreement has very key provisions on climate change. This is an innovative provision that has reconceptualized or will reconceptualize the international law of investment framework. Now, one important provision it creates is substantive provisions, not in the preambles, which one of them is promoting sustainable investment, giving states the right to cooperate with other states to technology exchange, to encourage green investments. And again, it has greatly streamlined the protection of foreign investors now. So in the sense of only protecting investments that are sustainable. So fossil fuel investments will be one way or the other outside the scope of this new investment treaty. Secondly,
1 minute more.
I'm rounding up. Secondly, the obligation of the non-state actors, such as foreign investors, they have the obligation to ensure that their activities are carried out in order of promoting climate action. Now, you can see that the AU's approach here is very aggressive, given that it's a very strong statement made on climate change in investment law. The AU is not conservative here, and there are innovative and ambitious provisions regarding climate action in its investment agreements. With this, I would like to conclude that overall, climate change objectives have found integration in AU investment law with the coming into force of the new African Investment Protocol. And yes, the AU, I would say, is a global actor in reconceptualizing investment law in the context of climate change. Thank you. With this, I will turn my attention back to Professor Bankole. Thank you. I hope I was within time. Thank you.
Thank you very much, okay. Very interesting, particularly underscoring the change in AU law and being bold enough to encourage climate change. We'll come back to you later as to how this works in other states, in the national members. Right now, I'd like to call on Aya to give her presentation.
Thank you, Chair. Let me share the slides.
Please go ahead.
Yes. Is it shared now?
Yes, it is.
Okay. Thank you. Wait. Oops. All right. So I teach international economic law at Nihon University in Japan. So my comments today will be limited to trade perspective, in particular the WTO law, but I may touch upon the FTA issues because the world trade is governed by the WTO agreement as well as FTAs today. But before starting, let me express my sincere appreciation to the Institute and Iris and Drinda, who had communicated with me in advance. And I'm grateful to have the opportunity to attend here. Now, my comments will touch upon the 6 points shown in the slides now. And some of them overlap with the points stated in the draft discussion paper presented by the Institute. But still, I hope I can contribute in some ways. Let me first start how the rules-based concept is perceived in the context of the WTO. See, here, excuse me, I'm trying to, oops. Here, the term rules-based is often used in the context of the WTO, and there seems to be broad acceptance in the international community that the WTO is rules-based, that it is closely related to the rules-based trading system, and that the WTO is understood to be its core. And we can see that on the WTO website, WTO itself mentions that WTO is rules-based, and its rules are negotiated agreements. And also, very recently, a Deputy Director General of the WTO has referred the WTO the rules-based trading system. And if you look at the WTO members as a group like G7, G20, or African ministers of trade, in their statements or summaries, explicitly state that WTO is related to rules-based trading system, and sometimes positioning the WTO at its core. And even I did some researches for individual countries. Only 5 is stated here, but I'm sure there are others. And these countries states also that WTO relates to the rules-based multilateral trading system. And sometimes the WTO at its core. Okay, and wait, I can't move this. I'm sorry. And then, so I explicitly state that in the WTO context, the rules are negotiated agreement. So the question is, what based means in the WTO sense. So here there are 2 agreements, namely SPS agreement and the TBT agreement in the WTO, that explicitly has the provisions states at the base or as a basis, and the dispute settlement system of the WTO that are consisted of panel and the appellate body have interpreted these terms. And these are relevant precedents. I just listed here, Ishii Holman's U.S. animals, and Ishii sardines, and some of you might heard about that. I don't go into details of the exact interpretations of these decisions, but in light of these interpretations, and if I apply these interpretations into the rules-based international order, then it would be like this. International order does not have to fully conform to the rules, but it shall be founded or built upon or supported by the rules such that they serve as principal constituent or fundamental principle of the international order. There needs to be very strong and very close relationship between the 2, and at the minimum, the 2 shall not be contradictory. Now, having said that, these lead us to two questions. One is that while rules-based is often used in the WTO context, the term member-driven is equally often referred to in the WTO. So the question would be, what does it mean in relation to rules-based? Whether they are contradictory, complementary, or irrelevant. And also the question would be, is this question specific to the WTO? See, I just listed the WTO homepage address saying that WTO is member-driven, with decisions taken by consensus among all member governments. And secondly, in the WTO, again, the rules are negotiated agreements in the strict sense. So the way in which these agreements are formed and negotiated could be an important element. And so the design of the negotiation process, the sense of acceptance of the negotiation, and or other elements could come into play. I can say that from the example of the TRIPS agreement, this is agreement which protects the intellectual properties. And this agreement came into force in 1995 with the advent of the WTO. But soon after, the developing countries mentioned that it is very difficult for them to implement this agreement because at that time, the negotiation was mainly led by so-called Quad. The developing countries signed this agreement as a part of a whole package without fully understanding the content agreement. So here you can see the negotiation process as well as the sense of acceptance is crucial for later on. And also today, trade is not contained to trade itself. It involves other non-trade issues such as trade and environment and trade human rights and digital trade, just to name a few. So these brings us questions like maybe more stakeholders should be included or in the process of the negotiations or formation of the rules. Now, it is also important that in the rules-based international order that there are the enforcement mechanisms. And in this respect, the history of the WTO dispute settlement procedure is very instructive. And some of you are aware that the WTO dispute settlement system has very worked well for 20 years. But since 2019, the APIC body, which is the upper organs of the WTO dispute settlement system, has stopped functioning. So we can maybe we can draw the lesson from there, such as what would be the appropriate balance between ensuring enforcement and reducing discretion of members, and also to what extent should external environment changes, such as changes in the international economic environment, like change of the power balance between leading nations, be taken into in the design of enforcement mechanisms. And having said that, although the rules themselves can contribute to the development of international trade order. I forgot to mention trade. For example, in 1995, when WTO was born, the new agreements came into force. I already mentioned about TRIPS agreement, and the SPS agreement was also new.
1 minute more. Yeah.
Pardon?
1 minute more.
I'm sorry. Yes, I'll be in a hurry. Okay. And after then, the FTAs concluded after 1995 started to include these new areas such as intellectual property and SPS. So you see, the rules introduce new rules later on, and we see the situation other way around. FTAs are now serving as laboratories for new rules such as trade and environment or digital trade. Now, finally, I like to stress that there are concepts that surrounds and affects in the rules, and key example would be sustainable development. I think you might be aware that this concept came in late 1980s, and it was reflected in WTO agreement, and now today SDGs explicitly refers to the WTO, and also WTO commits itself to the SDGs. And also we see the FTA articles explicitly providing the SDGs, such as CPTPP, Japan, EU, and also African continental free trade areas. So I hope I didn't pass time so much, and I stop here. Thank you.
Thank you very much, Aya. It's interesting the point you made that the WTO is a rules-based organization, and so maybe the concept of rules-based is not completely new, as been suggested by some others, but we'll take that up during further discussions and question time. Thank you so much.
Okay. Thank
Federico,
you.
over to you. Indigenous people's rights. What's your experience? What are the issues?
Oh, yeah, thank you. Can you hear me?
Very well.
Great, great. Yes, first of all, thank you for inviting me to join you today. And it is a very stimulating discussion because it is not so usual in the context of the work that I'm used to do, including when we have this kind of event. So it led me to reflect a lot about this issue of rules-based international order and indigenous peoples. Now, the rights of indigenous peoples have recently developed, and in the room there is Alexandra. We have shared many discussions and many moments together concerning the status, evolution, and development of indigenous peoples' rights in international law. And they are to some extent sui generis, because they have a characterization which is unique to some extent, not only for the reason that they introduce within international law a dynamics of human rights, which I'm not saying that was totally original, but was not easily accepted by the majority of states. And I'm talking about collective rights and the fact that individual rights basically find realization within the realm of the community, within the realm of the group. But also for the reason that, yes, we have some international legal rules, and in 1 minute, I will briefly expose the most important of these rules, but they have to interact with different kind of law and different kind of rules. And especially I'm referring to the customary law of indigenous people, so their customs and traditions, which are rules indeed. And they're very important because they have been progressively introduced within the dynamics of international law, especially by human rights monitoring bodies. And of course, the champion in this respect is the Inter-American Court of Human Rights. But the example of the court has been followed, in some cases even anticipated by other human rights monitoring bodies, even though they have not reached the same advanced type of evolutionary interpretation of human rights standards as the Inter-American Court. I was saying that these rules originating internally in the context of indigenous peoples have influenced notably the interpretation and the application of rules arising from public international law, bringing them to a transformation. We could refer to a number of rights which today are recognized by international law, sorry, in favor of indigenous peoples, which are the right to self-determination, even though it is to be conceived in the form of internal self-determination, so which does not imply any right to secession from the states where they live, but it is a right which gives indigenous peoples a notable amount of self-government and autonomy, especially concerning their internal matters. But even though these matters are internal to the community, they necessarily interact with the regulation of the life of people external to the community itself. So they enter within the dynamics of domestic and international law, or I would say first international law, and then in most cases they have been transmitted to domestic law in the form of obligations arising from international law. And these rules also include the right to cultural identity. They include the right to reparation and redress for wrongs suffered in the past, but especially I would use the example of land rights, the right to the possession of traditional lands, which today can be considered as arising from an amalgam of rules arising in the context of public international law, because we can mention, of course, treaty rules, especially the ILO Convention 169 of 1989, even though the rate of ratification of this convention is still today quite low. And we could say that it is really effective only in the Latin American continent. And there are roots arising from soft law. I heard at the end of the previous panel that the importance of soft law was emphasized as a kind of law which is very important in the progressive formation of hard law, and so in the evolution of international law. And in my opinion, even though I had to admit that this position can be considered as controversial, but today is shared by the majority of scholars in the field, there are also rules arising from customary international law concerning the most important rights of indigenous peoples of collective character. And what I was saying is that the contents of these rules, which of course give rise to a rules-based international order, have been strongly influenced by something which was exogenous to public international law. And again, I refer to the customary international law, customs and traditions of indigenous peoples. In this respect, I was intrigued by certain parts of the paper that we are discussing today. And there was especially the part in which the authors were wondering whether a system, a rules-based international order is synonymous of international law, and so overlaps totally with public international law, or on the contrary, this overlapping is only partial. I totally agree with the approach followed in the paper, in the sense that the more a rules-based international order is based on public international law, the more there is a stability, the more there is a certainty in the application of laws, and especially there are methods through which it is possible to enforce the relevant international rules. On the contrary, if we would admit the introduction in this rules-based international order of rules which are not part of public international law, there would be the danger of different interpretations, abuses, and so on, of course, if I understood correctly. But at the same time, in my mind, I cannot avoid to think that the tendency to political manipulation and double standards is inherent in public international law. I mean, in many occasions, states try to manipulate international rules for their political interest. And this happens very often when it comes to the rights of indigenous peoples. For instance, some states, I would say many states, try all the time to...
1 minute more.
1 minute, okay. Try all the time to get around those rules, those existing rules of international law in order to avoid their obligations in the field. So, for instance, there is the issue of the lack of a proper definition of indigenous peoples, which allows states to deny that certain communities living in their territories are indigenous. So what I want to say, and I hope that it could be an interesting addition to the discussion, is that a rules-based international order, and this is my conclusion, yes, must be based on public international law. But in my opinion, we would need something else in addition. That would be a recourse to certain values that I would say they are natural in the coexistence of human communities, which are values like fairness, justice, that should suggest the way how international rules should be applied. So we would need to circumvent this propensity of states to not to properly apply international rules in order to promote their political interests. So in addition to the rules, which in themselves are essential, we would also need the propensity to apply these rules in the right way in order to realize a fair and just rules-based international order. Thank you.
Thank you so much, Federico. A lot of food for thoughts, particularly your arguments that the rules of customs of indigenous people that may not have been part of private international law or public international law, sorry, are gradually being recognized or must be recognized. We'll come back to that theme. Thank you so much. Alexandra, your experience as a UN Special Rapporteur on cultural rights, it's very, very informative. I've been following this and would like to hear from you.
Thank you very much. Today I have been asked to kind of focus more on indigenous rights and in the African context, but I will bring in, of course, cultural rights. So I am trying to see whether the rules-based international order works and why it should work for cultural rights and for indigenous people's rights and for human rights in general, whether it will be in the African context or somewhere else. And I really cannot see why we should adopt something that is vague, that is not specific, and that the way it is now, it gives a way out to states from binding obligations that they have. In my view, from time to time, we see these new concepts that, kind of sprung up, and it's a way of states to undermine and not to take into account all the nuances and all the soft different understandings that the human rights system has to offer. So contrary to what the first panel said, I completely disagree with adopting this rhetoric that has been found nowhere so far in any international law instrument, because this lowers the standards of international human rights law. So, and I'm going to kind of focus my disagreement on two issues, one specific and one generic. So first of all, exactly what the previous speakers have said, rules. So this international order is based on rules. Which rules? Who sets the rules? What are the rules? And also, why focus only on rules? And it reminds me of, going to a foreign office at some stage to offer my little wisdom that I may have on indigenous rights, and they wanted me to talk only about treaties, nothing else. So the moment I said, yeah, but what about the Declaration on the Rights of Indigenous Peoples? They said, oh, no, we only want rules. We only want treaty provisions. And of course, international human rights law does not work like that. So at least, you know, soft law interprets the existing rules. So, you know, by adopting the international, the rules-based international order, we nullify all these nuances and discussions and ways of interpreting the provisions, the binding provisions that states have undertaken. And this is a massive issue in general when it comes to human rights. There are discussions, nuances, disagreements, that case law, different judges saying different things, that we all international lawyers and you know, all treaty bodies and carry with them. And you know, that's how international law evolves. And you cannot just ignore these and focus only on treaty provisions. So, you know, there has been a lot of discussion on whether international law includes soft law or not, whether it is outside of international law, whether it is inside the scope of international law. And there's a lot of literature in this respect. In my view, I have always said that when I talk about international law, and even more so international human rights law, it includes, of course, soft law, and this is not reflected in this newish concept. Also, so this is my one objection. And it's very interesting that we talked about WTO and the World Bank, because of course, by using repeatedly rules-based international order, they can distinguish and they can shape which parts of international law they're going to respect and which parts they're going to just put on the side. And the World Bank and WTO are not these amorphous institutions. They comprise of states, and it is the states that carry with them the binding international legal obligations that international human rights law has recognized and they have signed and undertaken. So in my report last year to the UN General Assembly as the UN Special Rapporteur in the field of cultural rights, I emphasized that the international governance has to take into account cultural rights. And by international governance, I also included the states that are in the World Bank and in the WTO. And I think that this is very important. For indigenous peoples, it's exactly what Professor Lenzerini said. We kind of, this idea of the soft law became almost a theoretical question because we all emphasize that the UNDRIP, the Declaration on the Rights of Indigenous Peoples, has such an important position within the human rights system that it is legally binding, and like Federico said, gradually at least some of its provisions are customary international law. This is something that states have been resisting, and you know, we celebrated Western maybe states kind of saying yes it is, but we never focus so much on the silent state. So I remember Japan, for example. Japan kept emphasizing that international human rights law is about individual rights. Well, yes, of course, if we talk about rules-based international order, maybe, you know, states like Japan can say this, can bring this. But if we talk about international human rights law, you know, these states like the UK also said, you know, we don't recognize collective rights. They cannot anymore, you know, say that this is the case. You know, collective rights are recognized. So, and we also see this kind of the loss of the importance of the nuances included in soft law when it comes to the African states. So the African states, like you know, Federico said, have traditionally had a very big reluctance and difficulty in recognizing the concept of indigenous peoples. Indigenous identity has been more contentious or contended in many African states than in the Americas, for example. But across the continent, there are marginalized peoples across Africa who have a very old customary attachment to their lands, to the lands they inhabit, a unique culture and a strong sense of collective identity. So international human rights law is very clear that when we talk about indigenous peoples, we don't just, we don't talk about priority anymore, but we talk about marginalization. And this is the way that we define indigenous peoples. All this debate is going to be lost if we focus on, a very arbitrary, rules-based international order. The idea that African states sometimes kind of push forward is that international human rights law should be about decolonization and, decolonizing international human rights law. Yet when they come to their own kind of discussions about decolonizing indigenous peoples, then, the debate is not very clear who decolonizes whom. And we do have, at the moment, indigenous peoples, the Batwa, for example, and others that, are being oppressed by other indigenous peoples who are being oppressed by other indigenous people. So we have a very clear hierarchy in Africa of indigenous peoples being excluded and marginalized. And we have to, and it is soft law that gives us the tools to ensure that these people at some stage become actually free. And free of a hierarchy that has been imposed on them. And where this hierarchy comes from, we can, take a lot of time discussing, but the reality is that this hierarchy has to stop. So, I think that it is very important to continue to talk about international human rights law and the nuances of international human rights law. And of course, in this respect, soft law. The second issue is a little bit more generic, so kind of in between. It is about the liberal order that has been the ancestor, if you wish, of the rule-based international order. So liberals do not recognize collective rights. Liberals traditionally do not recognize social, economic, and cultural rights. Hence, they do not tackle the economic, social, economic, and cultural factors that continue to oppress indigenous peoples. And so by not talking about these issues, we continue to have the foundations of oppression when it comes to indigenous peoples. And of course, as Federico said, I'm not going to get very much into that land grabbing. This is very much part of public international law debate. The liberals do not recognize the right to development. And traditionally, there is a stop, and I think somebody in the first panel very accurately reflected on this. So, again, we would exclude this. So it is very much a choose and, first of all, it is a very vague issue. What do we mean by rules-based? Which rules? And secondly, states who are the liberators, but also the oppressors, can pick and choose.
1 minute more.
Sure, these rules. But I think that more generally, the more general issue that I have is that, in trying to decolonize, minds and attitudes and values, we have been spending a lot of time in international human rights law reevaluating concepts and getting away from the liberal approach as the optimal. And we've been, as a UN Special Rapporteur on Cultural Rights, I've been doing a lot of work trying to ensure, and Federico and a lot of others, a lot of work trying to ensure that international law per se is decolonized. And yes, it has not happened completely yet, but we have a whole debate and a whole history on this. And to go back to discussions that are based on the liberal approach, as if this is the optimal approach, just, brings us back to where we were about 20 years ago. So for these reasons, I do not like rules-based international order, and I am very clear that I will continue to talk, about legal obligations that states have, because they have undertaken these obligations and because the international community has interpreted the scope of these obligations, which is what we call public international law. Thank you.
Thank you very much. Very interesting debate it has been. I think we have time for questions and answers. I have a few questions, and maybe those in the audience may follow up with this. Starting from perhaps Alexandra, collective rights must be recognized. That's a very strong theme in your discussion. Can you share your views on the reluctance of the British Museum to return the artifacts looted across Africa during the colonial era because of the British Museum statute that forbids such return?
I cannot share my views about the British Museum because, as a UN Special Rapporteur, I should be in touch with the state before I share any criticism that I have. However, I think that in my report to Germany only 2 weeks ago to the UN Human Rights Council, I did congratulate Germany for taking the position to ensure that objects that have been gained through colonialism are returned. And I did say that this is not a good practice. This is part of the legal obligations that states have undertaken by signing and ratifying the International Covenant on Economic, Social and Cultural Rights, and specifically Article 15. So I hope that this gives you an answer.
Yeah, thank you very much. I don't know whether Federico has a view on this, or whether he may also want to touch on the discussions at the World Intellectual Property Organization about having a treaty, an instrument for traditional knowledge.
Well, yes, of course, I have a view, and I agree with what Alexandra just said. It is a very controversial issue because there are many different interests in theory which conflict with each other. So when it comes to the return of these properties, on the one hand, you have the right of the owners, of the cultural owners of the properties to have them returned, which is a human right. On the other hand, the states claim that sometimes this is part of their national heritage, and then there is the issue of the enjoyment by the general public, which should be the main quality that should be pursued through the protection of cultural heritage. But in most cases, in my opinion, I don't think that I add anything to what Alexandra just said. My opinion is that in most cases, these arguments, even though they can be grounded on legal rules, especially I would say of national character, but in reality, their excuse is not to comply with an international obligations, which today, still in my opinion, really exists. And it arises from human rights standards if they are applied and interpreted correctly. So probably it is an indirect kind of obligation, which is not specifically mentioned by human rights treaties. But if you want to provide effectiveness of these human rights, so effective enjoyment by the relevant communities, this is one action which should be carried out by governments, because especially when it comes to indigenous peoples, current generations continue to tangibly suffer the effects of the deprivation of their cultural heritage, even if it was taken to the previous generations many years ago. So this is a kind of continuing violation of human rights in technical terms, which requires justice today. This is my position, basically.
Thank you very much, Federico. Aya, you did say that stakeholders, some other stakeholders should be involved in the formulation or enforcement of the rules. Could you throw some more light on this?
I'm sorry, I missed the first part of the question. Can you repeat that?
Yeah, you said stakeholders in your earlier address should be involved, should be included in the formulation of an enforcement of the rules. Could you, throw some more light on what you mean?
Yes, thank you, Chair. Well, again, there I said, I stressed that trade is not only trade issues today. Trade is more related to other issues like environment and human rights and digital issues. And in these circumstances, I see that already in some FTAs provide the more stakeholders to be involved in the process, not necessarily in the negotiation process, maybe the implementation process of the agreements. But we see already the such broader stakeholders involvement in the agreements, in the trade agreements. And but in this WTO, negotiations are conducted on the members only. So I think that might be already questionable whether it is appropriate to limit the WTO negotiations to only the nations if the trade and if the issues such as trade and environment, if the impact is huge for outside the trade, I think maybe the more stakeholders should be involved in the negotiations and implementation stage. That's what I mentioned. I hope I'm making myself clear.
Yeah, because even in investment treaty arbitration these days, ICSID allows third parties, stakeholders to put in representation. So thank you for that. You did say that the AU law now accommodates climate change issues. My question for you is, do the BITs, the bilateral investment treaties that many African countries have signed, do they mention or allow climate change to be a kind of defense or shield for African nations? And if they don't, what do you think may happen? Is there no conflict between the AU and the BITs?
Thank you, Chair. That's a very good question. With the coming into force of the AU investment protocol, automatically there's a mandatory provision that all intra-bilateral investment treaties between African states shall be terminated. So in this sense, you wouldn't have any conflicting issue where BITs do or do not contain enforceable climate change rights. However, there's still a gray area when it comes to African states entering into investment treaties with third countries. These are countries that are outside the EU. For instance, we are seeing the Tanzanian government enter into a treaty with Canada. So that would create issues if that treaty somehow conflicts with the African Investment Protocol, because the African Investment Protocol contains an most favored nation clause that could be invoked by a foreign investor from Canada if they do not want to be protected or under the African Investment Protocol. In essence, they wouldn't be. So that's the only issue. But if it's intra-BITs, those treaties will be terminated upon coming into force of the African Investment Protocol. I hope I addressed your question. Thank you.
Certainly. Thank you so much. I don't know whether there are any questions in the those who are there physically or anything online.
Yes.
I'm trying to get
Yes,
the ones
there
online.
are some, but there was also something online, but I will give the floor immediately to one of the...
Thank you very much indeed. I'm William Horsley, University of Sheffield. I was a BBC international reporter for a long time, and I think the origin of this idea of a rules-based international order is in the collapse or slide of the geopolitical system that came into being in 1990, effectively with the end of communism. And I was very struck by the roll call of members or leaders of the rules-based order idea, including Kenya. And I'd like the panel to examine a little bit the motivations and the substance of the objections of the global South, which have a bit writ large since particularly Russia's invasion of Ukraine and so on. It would seem to me that a more charitable interpretation of the rules-based order would be that the Western countries, for all their sins in the colonial era and their inconsistencies, have felt responsible for the world strategic order and keeping the peace with nuclear arms agreements and so on for many decades. And since about the late 80s until 2000, there was a flowering of democracy, the idea, of course, of the end of history in that sense. But the UN and international organizations do recognize there's been a democratic backsliding in general since then. And that includes the collapse of things like the OSCE agreements, which were collective. So the idea of a consensus, which was behind this rise of democracy. So where does the global south, some of the countries like Kenya, stand in relation to that larger picture and their adherence to the idea of democracy in the sense of democratic standards inside a country and the respect for international borders, which is obviously being violated now, especially in Ukraine. Thank you.
Yeah. Any more persons from the audience? If no other questions online?
Yes, there is one.
Good.
Oh, no, it was a misunderstanding. Then there was a question online, I guess.
Yes, but I'm trying to trace it. I can't really get it here. Can somebody help us?
There is a question from Uma. And then it's actually a comment rather than a question, because she's currently involved in drafting the upcoming diplomatic conference on WIPO Treaty on traditional knowledge and intellectual property. She's struggling to argue that certain clauses on prior informed consent or disclosure remained inside the treaty so as to create norms. It's very difficult as it is political, and she rather liked to the idea of rules-based international order, which incorporates perhaps national or customary norms.
Well, I mean, I don't know whether Federico or Alexandra wants to respond to that. Otherwise, I give my comments.
Yes, but Federico may also want to.
Please go ahead.
Okay. So
if you wish, I can hear and I can talk, but without activating the video.
Yeah.
So
Go
should I
ahead.
go first, or do you want to go first, Federico?
But maybe Alexandra would be more qualified than me to
Go
provide
first,
an
Alexandra.
answer.
Go first,
Sorry
Alexandra.
about that, but I think that so free, prior, and informed consent is an emerging standard, but it is an application of the right to participation together with the right to self-determination that that indigenous peoples have. So in this respect, it is included in international human rights law, and I would not have any problems putting it in there. More and more we see it recognized, internationally. I was arguing back in 2016 that it was emerging standard. I think that now, if I was to write or to kind of comment on it, I would say that it is an existing, well-established standard, and I would not see a problem with that. And wow, what a fantastic task the participant has at the moment. I'm very jealous.
Yeah, thank you very much. Federico, do you have anything else to add?
Yes, I can say that
It's just me. I can't hear you. Federico?
I can't hear him either.
Okay, there must be a hitch there. But if I may add, I just like Alexandra said, there are other international instruments that have recognized issues of prior consent, issues of benefit sharing, and this must be in the treaty. It's exciting for me because about 25 years ago, there's some research which I did with a professor in Malaysia University and also Professor Spiros Mayatis of Bickel, looking at those kind of concepts, which today is coming together. They're coming together as traditional knowledge for the treaty. So I just think we need to keep on pushing, and someday the global South may push and get some of what they want, and someday there may be a better balance. Because of time, I think I'll like to round up here. I think it's been a very stimulating time. I want to thank the speakers, Iino, Alexandra, and Federico, and thank Bickel for setting up this most stimulating meeting. I believe that there's going to be room for more collaboration among us all, so that the concept paper will crystallize, and then we don't know where we'll go from here. Thank you very much for the opportunity.
Thank you very much
Thank
to
you.
the second panel and to the speakers and the chair. Thanks to all of you who joined and remained until now for the fruitful discussion and dynamic, but also for the honest sharing of views, whether you agree or disagree with this concept, which was actually the whole purpose of the event, but also of the paper. Apologies for not mentioning, we had one miss today, which was one of the speakers of the first panel. You might have noticed from the program, Professor Phoebe Okowa, she couldn't make it today, but we managed to keep the two panels balanced, at least in terms of speakers and then the time for the Q&A. Another round of applause I would ask, please, for the speakers and for all the participants here. Thanks a lot and see you again, hopefully soon.